Damn, I didn't realize I was echoing. Sorry. Alright, guys, I am barely fucking awake. So, good morning, everyone. But I'm literally barely awake. My eyes are like barely open. So, bear with me here. Hold on. Alright, now you can see chat. But I am like literally barely awake. I need a few moments. Hold on. No, here it is. I was like, why can I not find it? Alright, so we'll give it a minute. Hey, Shelby. I know there's no maid service to clean up. This maid is out of it. Alright, what about now? Can you hear me now? Alright, judge is walking in.
All right, good morning. All right, it's my understanding that the defense is resting, is that correct? All right, I'm not going to bring the jury out just to take them back in, so after we finish our motions and they come out, I'll let you say that, yeah, okay, let's just do it that way. All right, so based on them resting, you have a motion?
Yes.
And I did receive your memo ahead of time, so I have reviewed that. Okay, I have that, okay. Yes, sir?
I haven't received anything from them. I don't know whether they filed it.
I think it's just going to be oral arguments. Yes, sir.
I haven't received anything from them. I don't know whether they filed it.
I think it's just going to be oral arguments. Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief and it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the three statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipses. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard
What's wrong with the
cannot prevail
audio?
on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the three statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the three statements at issue. It is undisputed that Mr. Depp did not make any of the three statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here, there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his
he's like kind of boring.
Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly.
He should have this, like,
See
memorized.
Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp. versus Alston, 236 Virginia, 152 at page 156. Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp. Versus Holbert case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false.
Wow,
and
he
Mr.
is
Depp's
really
knowledge
boring.
cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr.
This is
Waldman
when
had very
ADHD kicks in and you start
grounds
looking
to
at
believe,
Amber's hair.
and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008.
He's reading someone else's notes, and it's obvious.
But his testimony that two trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forums at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016.
Bottom line
when she
is,
walked
he's just
in
trying to get
to court
her
with
counterclaim
her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura DeVenier, Melanie Iglesias, who, as Your Honor recalls, was
He's just using
Ms. Heard's makeup
stuff
artist,
against
who
her.
decided to end any professional or
Exactly,
personal
Chair. My
association with Ms.
ADHD is
Heard.
totally kicked in.
Samantha
I'm checking
McMillan,
out the curls in her
Hilda
hair.
Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Pass.
What an ugly color suit.
No reasonable jury
That is
could
ugly.
find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270
I don't like
Virginia,
it. I think it's ugly.
299 at 344.
See,
An
Catherine's ex had
independent
one classmate
contractor
and had
is a
she has a
person who
scar.
is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia 378.
Okay, don't come for me, but Amber's hair
That's a
looks pretty.
2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation.
Come on, lawyer, you
In that
need some
case,
passion behind
the employer
this.
was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are
He needs more passion in his
accomplished.
speaking. Come on.
Lawyers,
we need,
as Your Honor
we
has
need more
reminded
oomph.
us, are subject
Oomph.
to professional obligations
Give us
to
some oomph.
exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client,
Exactly.
a
It's
lawyer
like sleepy
shall
time.
exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly
Hey, East
for
Coast.
statements about which he was unaware until he was sued for them.
Come on, there's no passion
Mr.
behind
Waldman
this.
testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan-out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken.
I agree.
Is that
She
Mr.
does look
Waldman's
like she has
statements were
bruises.
protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable.
Okay, you're
expressions
not
of
getting a
opinion
counterclaim
entitled
dismissed
to
with no
protection under
passion
the
at
First
all.
Amendment.
It's not gonna
See
happen.
Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Buffalt, a Virginia Supreme Court case found at 290 Virginia
I do live for
83,
passion and
a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the
I
assertion
can't
of
tell
deceit
if his tie is
reasonably could be
koala bears or
understood only
Ferraris.
as the speaker's personal conclusion, unquote, and finding in an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the
Because I open up the microphone and the desktop at the same time. Is that better?
Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into articles in which both points of view were clearly expressed, and Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, The most unsophisticated recipient of such a claim, i.e., any reader of the British tabloid, made by a competitor against another, could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed. And there was no doubt about that.
Can anyone tell me one thing this man just said?
Turning to the second part,
I don't remember
of the
anything
argument,
he
which
just
will be
said.
more abridged,
That's how
Ms.
boring
Heard
he is.
not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they
Lacey,
are.
I think that would make him lose.
Here,
Just saying.
in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it.
What the fuck is he rambling about?
What he is suing about here are the three statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say, what Mr. Depp is suing about are the three statements, and it's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article, and it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally
right now he's thinking You know
A
what?
matter of
I
public
should call Laura
concern is
before
one
lunch or
which
after
relates
lunch
to,
and
quote,
set up
a
the
matter
time.
of a political,
That's what he's
social,
thinking right
or
now.
other concern to the community, unquote.
As opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146.
I did see that paper, Moon.
Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not
rise
Now
to
he's
the level
thinking,
of a
where should
matter
I
of
take
public
Laura for
concern
dinner?
with
Should I
broader
take her to a
implications for
steakhouse or
society
should we go for
beyond
seafood or should
the
we
two
eat in?
litigants in this
That's what he's
action
thinking
any
right now.
more than Mr. Waldman's statements.
I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put
in to make
I
it
will
clear
share
the
when he
implication
calls.
that it was about Mr. Depp. They had
I think
lawyers
he's
from the
decided
ACLU
he'll call me before lunch. Just to pop in and say
working
hi.
around the clock with
Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who was not only their corporate representative, he was their general counsel.
I would hope his taste is better than Arby's.
They knew
Just
exactly
saying.
what they were doing, Your Honor. And one of the
He referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't
believe would
Kat,
fit
then I say
in
the
his
same thing.
narrative.
Who else
It
would
fit
she
in
be
the story that
implicating?
he was
Totally
speaking
agree with
about
that.
on behalf of Mr. Depp.
And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor has heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of
But
the
the
agent,
difference is she's a nobody. He's not a nobody. That's the difference.
He was standing
They're
in the
making it
shoes
out
of
like
Mr.
she's
Depp.
some big
They are
star.
one and the
She's
same
not.
for the purposes of those
statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument. On the actual malice argument, the evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them
That's what I'm
conspired to
saying,
falsely
Catherine.
accuse Amber of creating a hoax and falsify evidence.
Her lawyers, rightfully so, but her lawyers are trying to make her as big as he is. It's
As Your Honor
not.
well knows too, I won't go
She's
through
a
all the law,
nobody.
but both
Agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney
I'm going to make coffee. I'll be
client
right
have a
back.
principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are as a matter of law regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows the jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu, feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
All right. Yes, sir.
Your Honor, I will be brief in deference to the court's time and the jury's time. What Mr. Rottenborn said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur, red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship, and that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient in a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right. Thank you, sir. All right. In this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether the statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor. Duh.
Okay.
We knew that was going to happen. Okay. I should have slept in late. Because this is boring. Uh-oh. So what did we learn today? We learned that you can't strike a counterclaim based on Rotten Butt has been her attorney from day one. That's about all I can remember from what everybody said. And that girl that just took a sip of water has beautiful hair. I remember nothing from what they just said. This is where ADHD kicks in. I'm ready for a nap. Johnny's deciding he wanted hamburgers. So now he's looking up where to get hamburgers. She looks like she's wearing a diaper. Attorney Rubberton? I call him Rotten Butt. Hey, Marisa. Exactly. It's not even that it's over my head. It just bores me. That's the problem. I get bored so easily. Look at this kid. This poor kid was dragged in by his mom and his sister. Look at these characters as people. What a group. Let's wake up at 8 o'clock in the morning to go see Johnny Depp. Her hair is amazing. Her face, gotta go. But her hair is amazing. Ugly ass face. But amazing hair. She's such a bitch. I did get bored in school. I was horrible in school. And we didn't even know what ADHD was when I was in school. Hair's great. Face looks like a foot. I'm telling you. Believe me, lucky you just came in. I know. I know that when I said 8 o'clock, I meant last night. Oh. So you guys want to see a picture of the fam? Hold on. I'm trying to think where I have it besides my phone. There you go. Picture of the fam. I look so little. And I'm 5'8". So what does that tell you? Thanks, Karen. Yeah, mom's in yellow. Phoenix, Dayton, me, Sage, mom. And Howard took the picture. Did I get up on the wrong side? Yes. I'm just tired. Good morning, Robin. Yeah, we went to these cathedral caves. It was actually really cool. I kept telling the kids I was going to throw them off. Yeah, Dayton is like 6'3", Phoenix is 6'1.5", Sage is 5'10". Oh, yeah. Mom's 5'7", and I'm 5'8", but I look short. Right? Didn't I look little? I actually look just like my dad. Yes. I have a short video up. Thank you, Catherine. I have a short video up. I took a bunch of videos. I just haven't put it all together yet. I know, what are they doing? I am, Catherine. I've come a long way. Hang on, let me see if I can get this up in time. Hang on a second. Alright, you guys ready to laugh your ass off? This is probably the biggest difference yet. So, yeah. Those of you that have followed me for a long time are going to shit. 1 year. This is the difference 1 year makes. Ready? Ready, ready? How crazy is that? Isn't that crazy? Hey, Bonnie. When I saw that picture, I was like, holy shit. Even Sage was like, Mom, you weren't that big. I said, obviously I was. 1 year. Almost to the day. June 8th will be exactly a year. Crazy, right? £75. Isn't that crazy though? No, nobody realized I was that big. I didn't realize I was that big. Sage didn't realize I was that big. She was like, no fucking way, Mom. Crazy. Crazy, crazy. I know. Surgery alone, I know. But I'm not perfect. I mean, I'm picking on pretzels right now. Well, my highest was an 18, going into a 20, and now I'm a 10. Trying to get back down to a 6. And do you know a 10 is now considered large? We were in the mall yesterday, and Lane Bryant is now 10 to like some 10 to whatever. 10 to 26 or something. I was like, holy shit. I was like, 10 is now considered large? Progress, exactly. I had sent Brad's mom the picture. She's like, who's all the way to the left? I'm like, dummy, that's me. She's like, it is? I said, yeah. See, that's what it used to be. Not anymore. Me and my mom couldn't believe that 10 is now large. I know Old Navy makes it bigger, but me and Sage we went to a mall yesterday and we were in Hollister, and I tried on these pants that were at 30. I was like, wow, at 50 years old, I can wear Hollister clothes. I mean, I didn't particularly care for the pants once I had them on, but I was like, wow, I can shop in Hollister again. Because they have some really cute jeans. But I didn't like the way they fit. I don't like high-waisted. I'm too small bone for 14. I know 10's not large, but I'm saying now according to sizing, it is. Now according to sizing, 10 is overweight. That's true, Catherine. I look best between a 6 and an 8. I look too skinny between a 2 and a 4, but I look best between a 6 and an 8. I'm flabby though. Like I have 50-year-old legs. Some people have nice legs. I don't have nice legs. I've never had nice legs. Sage does. I have ugly legs. But I am very proud of how far I've come. There's one place saying that. That's crazy. They're wrong. Did you like doing your... Oh. Why is this taking so long? My God. But I'm very small boned. Yes, 10 used to be a medium, 12 and 14 was large. Now 10 is a large. But I am like extremely small boned. I really am. Some people like are broad. I have no shoulders. I'm very, very small boned. Thanks, Bonnie. And the home page of the website is done. I could show you guys that too, since they're taking forever. I still might change it a little bit so far. That's it. That's what we got so far. Homepage. All this time. You love it, Seashell? Any pirate candles? No. But I'm just glad I finally got the homepage done. Thank you, Be More Kind. See, I wasn't going to put so much on the front page, but I did. I have so many candles.
Okay.
Yay, finally. Nope, it's not ready to share. I still have a couple of weeks worth. I'm trying to get it done as fast as possible. When this trial's over, it'll be better. But I finished all current orders and all subscriptions. I know, they're going to take a break in like 5 minutes. I do have Hippie Christmas. All winter scents are going to be
I apologize. We have a few
in one
housekeeping
spot.
matters to take care of, but thank you. You can have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence.
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
She looks lost.
Your Honor, just to clarify, this is by deposition, so we may need
Oh,
that.
okay, well, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
If we could get the, yeah.
Yeah, you know, Seashell, I sent one to somebody and it got ruined in the mail. I couldn't believe it. I'm like, no. She showed me the picture. It was like it flipped upside down or something, and all the gel and the sand. I've never seen that before. I was like, oh my God, I cannot even believe that.
Ramada, what do you work for Warner Brothers Entertainment Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform an Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you
Don't let Big Soap
come to be the president of DC?
At the beginning of
Was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say.
Well,
So and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, it was the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Damn. That's interesting.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there, and would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
She's
At
average.
any time from
Below
the
average.
beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
Part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. Probably in 2018, latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script. Brought up.
All right, what, if anything, did Rob Cohen say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music.
I gotta be honest, I don't know why she keeps digging in this. It's not helping Amber.
Post-production, editing, sound design, music, etc.
What do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every set?
That is what we do in post-production. That's what filmmakers do. This is, on any production, you're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works. And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make the most successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2, is that correct? And
That's correct.
And Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying...
That'd be a test screening. So during our post-production of movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
And they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had, that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
Thank you. Your next witness.
All right, I was running Ikmel's stream during the deposition because his is much louder. But that's why mine was a little bit. Mine was actually 45 seconds ahead of his. But I don't know what that was about at the end. But the timestamp kept jumping in. It went from 10:08 to 10:15, then went from 10:15 to 10:25. I get the hiccups. So let me tell you where Johnny Depp's team went wrong. And I'm going to explain more of this when they go on break. The one person that they did not bring on trial that they needed to was someone from the music industry. And I stress this heavily because I know a lot about it. Johnny Depp is an artist. Johnny Depp is a musician. Johnny Depp is not a lawyer. He doesn't have the mentality of a normal person. And I know that sounds whacked, but he doesn't. Artists and musicians have completely different type of personalities than your average Joe. And they need to show that. And this is the one place they went wrong. And it's heavy. Like, if a jury could see this in depth, I think it would be an automatic win. But trying to portray him like he's just like your average Joe, or that he's just like somebody else, he's not at all. And it's really sad that they are not realizing this and not bringing somebody up that can explain it. Because in my opinion, it's so important. Whenever you have to deal with a musician, you have to treat them differently. They think differently, they act differently, they talk differently, their minds are different. Kind of like hands-on learners and, people that can, I forgot the technical names, but people that can learn by memorizing, and then there's people that learn by hands-on. It's the same thing. No matter how hard you try, you can't teach somebody hands-on if they're not that type of learner. And they have to be treated differently and, learn differently. I mean, that's what makes us, is that we see things differently. We do things differently. And I think that's a huge, huge factor that Johnny's team has let go. And they may not even realize it. A bunch of lawyers may not even realize it. Functional learners. But it's a huge difference. They should have absolutely had an expert on the stand. How many actors are dyslexic? Exactly. But I'm not even talking, I'm talking personality. Especially a lead singer. A lead singer has such a different type of personality than your normal person. That's one thing I know about my children. Like anyone that has multiple kids, all your kids are not the same. You can't teach them the same. You can't yell at them the same. Every single person is an individual. And that individuality, it will be the difference of how your kids react to you. If I yell at Phoenix, I can't yell at Phoenix the same way I yell at Sage or Dayton, because Phoenix won't grasp it. I don't yell at Dayton the way I would yell at Sage, because he wouldn't grasp it. Each one of them have different personalities and they respond differently to different things. And it's just huge that they needed to get somebody on the stand, and they didn't. But they really needed to get somebody on the stand that understood the way Johnny thinks. Johnny is an all-around artist. He's not even just a singer. He's an all-around artist. And artists are off-centered. They're weird. They're different. They think differently. They see the world differently. Where we may see the world with a blue sky, they see it as a teal sky or a purple sky. And to me, it's just huge that they didn't have anybody in to explain this. Or why nobody thought to have somebody come in and explain it. And as someone who spent years in the music business, this is key. Like, this is shit I know about. By the way, speaking of things I know about, off subject for a second, I don't know how many of you follow Making a Murderer, but Making a Murderer 3 is coming out on June 14th. As you guys know, Making a Murderer is what made my channel, and it's where I decided I was going to do YouTube, so I will be covering that in depth, episode by episode, probably more in depth than you've ever seen me, starting on June 14th. I'm going to try to run a Netflix group where everybody can watch it together. If for anyone that has Netflix, we can watch it together. Netflix has like this group thing that you can do as long as you already have Netflix. So I'm going to do that as well. But yeah, I'm pretty excited about it because there really hasn't been much movement in Making a Murderer at all. Yeah, Netflix. So, but part 3 is coming out on the 14th. So just to let you guys know, everything going on will be on hold because Making a Murderer is number 1. I know. I'm pretty excited to see what 3 is going to do. But I just want to let you guys know that. And I'm surprised Netflix is not, like, advertising. I found out from one of my Patreons. I can't wait either. I'm sure it's going to be much of nothing, but... Or more be kind, you could just go watch my videos. I have tons of videos on it. I know, right, Lacey? I'm really excited about it. Except his mom died. I don't know how many people know that. His mom died. Yeah, I didn't know either, Bailey. I just found out last night and then I looked it up. June 14th. But I read that it's going to be all the regular characters. It's going to focus on their jail sentencing. Well, originally they had a three-season deal, is what I was told, is what I read. So there was always going to be a third series. We just didn't know when. But anyone that knows me from Making a Murderer knows, like, I could tell you that case inside out, backwards, forwards.
All right, ladies and gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss the case and do not talk to anybody, okay? Do not do any outside research. Sorry, that was the same thing.
It is a horrible morning.
Take a break.
See, Joy, I have T-Mobile, and T-Mobile pays for our Netflix. Like, if you have a family plan, you get free Netflix.
Is that WebEx? Okay, so I'll get that set up too while we take the break as well. All right? All right, we'll go ahead and take a break. Let's make it 10:50 to give them time to look at everything, okay?
Which is good, so it doesn't even matter if they keep going up or not. All right. So yeah, so like I was saying, that's where they failed miserably. And especially someone like him who's an all-around artist. They're just focusing on the drug use and not on the artistry. It's a big mistake. I have T-Mobile. T-Mobile gives you free Netflix on a family plan. Which reminds me, I gotta call them. Oh, I gotta pay my rent today. I just remembered. So at lunchtime, I gotta go. I think they're gonna arrest today, though. I think this trial's over. But we shall see. Oh, is it Joy? See, I love T-Mobile. Although, I don't know why my bill is so high this month. I gotta call them. I've been with them since 2017. T-Mobile service around here is great. He is a different breed. A lot of musicians like him are. And that's why I really wish they would have had somebody to come in there. Yeah, I read that Kate Moss is scheduled. But I mean, like, I don't know, how much can they go back and forth? Like, so now he's calling up more witnesses, then she's going to call up more witnesses. I feel like this could go on forever. You know what I mean? Like, how much back and forth are they actually going to do? But I did read that she's scheduled to come back. She hasn't even been seen in a while, but she was also a pretty big drug addict. And at the same time, though, in all fairness, I really don't see how his ex-girlfriend from 30 years ago is going to make that much of an impact. You know, people change. And if I was on that jury, that's the one thing I would be thinking to myself, that people change. He could have been the perfect boyfriend 20 years ago. It doesn't mean he's a perfect boyfriend now. So I really wouldn't give weight up. I really wouldn't give too much weight to it. AH brought her up. She didn't want to be involved, so JD respected it. But Amber Turd said he abused her also. Well, because they had some kind of incident, right? Yes, they can. They can, Raquel. I believe they can. I don't want to say for sure, but I don't know. Kush told a lie about her, that Johnny tried to push her down the stairs. So they're just going to clarify that did not happen. Gotcha. I still look at this picture and I find it so odd. A woman holding a penis, stomping on a guy. He has been non-abusive in past. To me, screaming and slamming cabinets isn't abuse. No, but just remember, abuse in the eyes of the law is different than what you find as abuse. In the eyes of the law, many of the things he did and said is considered abusive. What one's personal boundaries are different. For example, in the eyes of the law, hitting someone in the back of the head, even joking, is considered physical abuse. Logically, if you're just joking around with your mate and you smack them in the back of the head, that's not abuse. You're joking, you're hanging out, you're playing. But in the eyes of the law, that's physical abuse. You put your hand on them. So that's where this case will be interesting. Because legally, and I say legally, he lost this case. Because she has proven that legally he was abusive. I'm not saying she wasn't, but he was abusive in the way he spoke to her, the text messages, everything. But will this be in the eyes of the law, or are they going to go by emotion depending on their personality? That's where this has interested me. Yeah, touching it all is abuse. That's what I'm saying. So, is he a wife beater? No. Is he an abuser? No. Is he a drug addict? Yes. But in the eyes of the law, is he an abuser? Hell yeah. And again, it just boils down to one's personal boundaries. Some people find it perfectly acceptable. I'm one of them. But some people find it perfectly acceptable joking around with your boyfriend, your husband, your wife, your girlfriend, and be like, yo, what's up, bitch? But technically, that's abusive. Legally, that's abuse. So will the judge rule it? No, not the judge. Is the jury going to rule it based on their own personal feelings and their own personal boundaries, or are they going to rule on legal? And again, if they rule it completely legally, she's won. But remember, this isn't about what she did to him. This is about him proving that he's not a wife beater, which I don't believe he is a wife beater at all, but he is abusive, or he was abusive. In the eyes of the law. Let me keep stressing that. In the eyes of the law. Legal term. I'm talking legal terms, not personal terms, not personal boundaries, just legally. And legally, he was abusive. So was she, though. That's why it could very well be a wash. In the court of public opinion, he won. Absolutely. Spanking, no, that's a good thing. Spank me harder. Hey, Kim. See, but Kim, think about your statement. I want you to really think about that for a second. Reverse that. What if it was a guy saying that she made me do it? Think about it. Now you're accepting abuse. Take yourself out of who he is. Take yourself out that it's Johnny Depp. Would you still be saying that? Think about it. Seriously, think about it. I do, Jay. You know what I'm saying? Seriously, think about it. He pushed me to do it. He pushed me to hit her. Now, I can take myself out of personal opinion and go just by the law, but that's because I know it and I've lived it. But you'll never hear me say that she deserved it. You've never heard me say that with Amber, and I wouldn't say that about anybody, because nobody deserves to be abused. On the flip side of that, though, I don't want anyone to think that I don't think she's a narcissistic bitch, because I do. But take out the fact that Johnny is a celebrity. Johnny is a drug addict, or was a drug addict. Johnny is an alcoholic, or was an alcoholic. Johnny was abusive in many ways. If he wasn't a celebrity, would you still be rooting for him? That's what you need to ask yourself. Like, seriously. If he wasn't rich and famous, would I still be rooting for him the same way? Or would I just look at him as just another drug addict? Because I know for a fact, and you guys know, that if he wasn't a drug addict, if he wasn't a celebrity, his drug addiction and alcoholism would be front and center. And I agree with you, Pearl. Believe me, I'm no fan of Amber. I'm just speaking from a legal term, not from a personal view. Personally, I think she's a narcissistic piece of shit who pushed and pushed and pushed him, and he tried to get away and he didn't get away. And he was in love with her and he was addicted to her. That's on a personal note. That's what I personally think. But what I think personally has nothing to do with what I see legally. And it's very, very hard to separate the two. I think the verbal was his way of defense. Oh, and I agree with you. That's why I'm saying don't mistake my personal view on what I'm explaining legally. Because I think she's a piece of shit. And I think she's a liar and a narcissist and just an asshole who pushed him and pushed and pushed and pushed. And started recording him before she even barely knew him. So I believe she was setting him up. So I can't stress enough my personal view over a legal view. Does not make him an abuser. I agree. But I'm saying, Robin, in the eyes of the law, he was abusive. In the eyes of the law. I totally agree, Pearl. But that, Robin, that's why I keep saying separate my view of personal as compared to legally. Because they really are two totally different things. Oh, yeah, she definitely used him for money and fame. There's no doubt about that. Now put them into what they say about women and women's battered syndrome. Oh, absolutely. I think it was definitely narcissistic abuse. She is a narcissist, and he was hooked. He was addicted to her. I mean, you can even see it in the pictures that he was in love with her, and she was disgusted by him. She was repulsed by him. Maybe she liked him for a minute, but for the most part, she wanted no part of him. That was so obvious in pictures. And she has history of beating her ex-wife. So this isn't new for him. I mean, this isn't new for her. This is who this bitch is. And in my opinion, it does make a difference depending on how the jury looks at it. But I'm telling you, the key of him winning was getting an expert from the music industry in. I should have told him when he called me earlier. All honestly, if I would have thought about it, I would have left a message for one of his attorneys and be like, look, you have to get somebody from the music industry in. I really would have. Because sadly, I don't think any of them even thought of it. Because they're all focusing on his movie career, not his music industry. They should have just never been together. Good point. You know, and that's the thing with him. He's more than just an actor. He's an artist. He's a musician. They didn't bring on any, like, Alice Cooper, Joe Perry, any of his music people. And they should have. Once my ex had my arm and wouldn't let go, I swung around and with my rings broke his front tooth. It would have never happened if he hadn't refused me the option to walk away. There you go. Yeah, but they had a music industry guy to testify, but not about Johnny's personality. They needed somebody to talk about Johnny's personality and a lead singer's personality. Maybe like a psychologist, two lead singers. I don't know. Just something. Because everyone in the music industry who's ever dealt with bands knows you have to speak to singers differently than you do the rest of the band. Singers and drummers have different personalities. Marilyn Manson, yeah, I can't stand Marilyn Manson. He's so phony. He's intelligent, but he's phony. But I mean, a lot of these bands have psychiatrists that go on tour with them or access to a psychologist all the time. I'm telling you, it really would have helped Johnny to have it. Who, Marilyn Manson? Yeah, but being part of his music career is not what I'm saying. I'm saying you need somebody to explain the mentality of a singer or of a drummer, because the mentality is just different. You have to speak to them differently. You have to approach them differently. Singers are very, very, very sensitive people. Artists in general are very sensitive people. And you need to speak. That's why a lot of guitarists do interviews, because guitarists are generally the most grounded in a band. Guitarists and bassists are usually the most grounded. Yeah, I don't care for his music, but I mean, his band it's Joe Perry, Alice Cooper, him. Drugs are usual in music. Do you know majority of bands fall apart due to the singer's attitude? No joke. That's usually why a band will fall apart as a singer. Because that's the one person that's very hard to replace. Because once you change the dynamic of a band, it's never the same. But a singer is the most important. Many bands will recover if you replace a guitarist or a bass player. Most bands will not recover if you replace a singer.
All right.
And we're back.
Yes, sir. Okay. Approach. Ms. Myers.
Not back yet. It is part of band life, unfortunately. Drummer has an attitude. That is correct. The drummers are very intelligent, but they're also a little off. Drummers are usually angry. But if you look at some of the best bands and I'm not talking artists, I'm talking full out bands, you'll see the personality changes and the singer is always a little off. And the better the singer is, the more off they are. And that's just a fact. I mean, it's part of the music industry. Then you have singer-songwriters. Drummers all have ADD. The drummer is the heart of the music, correct. But when writing a song, the singer is not there. The band writes it, and then the singer writes the lyrics to go along with it. Is the majority of how songs are written. Oh, are you, Cass? So you can confirm everything I'm saying. You know what I'm saying. Yeah, I'm trying to get Dayton back into drums. He's being a goober. No, I was a manager and an A&R scout for 1999 to 2004. God, it was so long ago. I left everything in 2004 because I was pregnant with the twins. I got pregnant. It was fun, though. Met a lot of good people. Made a lot of good friends. Spoke at a lot of conferences. And then got pregnant with twins and walked away from it all.
All right, yes. Are we ready for the jury?
Yes.
Okay. Sir, can you hear me?
Yes.
Can you hear me?
Yes, can you count to 5 for me?
1, 2, 3, 4, 5.
All right. I'm just trying to get you on the big screen. We're waiting for the jury. Just give us a minute, okay, sir?
Thank you.
I was just gonna say, why is she waiting for her to count to 5? I thought that was strange.
Thank you. You can be seated.
If anyone knows any metal bands, if you know the band Trivium,
Dr. Holger.
put a 1.
All right, sir, if you could raise your right hand. Do you swear or affirm to tell the truth under penalty of law?
Yes.
Your Honor, I would just object that Dr. Culver appears to have a stack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just testify from your memory, okay, sir? Thank you.
Thank you, Your Honor.
All right, your question?
Good morning, Dr. Culber.
Morning.
Could you please state your full name for the record?
David Allen Colbert.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years.
Where do you currently work?
At Cedars-Sinai Medical Center.
How long have you worked there?
For the past 26 years.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
When did Mr. Depp become your patient?
Sometime in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
Debriding the devitalized tissue, putting a hypothenar skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery? I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
It was injured and he had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
It was a plaster splint.
And can you please describe to the jury what a plaster splint would look like?
So it's like a cast, but you don't want to put everything circumferential on it because of swelling after surgery. So I believe in Mr. Depp's case, it was like the 2 fingers. I think the 3rd finger was the one that was operated on. So these 2 fingers, the 3rd and 4th finger together. And it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his 3rd and 4th fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be he had his index finger free and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury. It required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same. Around 2015.
All right. Thank you, Dr. Colbert.
All right, cross-examination.
Good morning, Dr. Colbert. So you said that this plaster splint was put on after surgery on March 20th, 2015?
Yes.
And a plaster
Yeah.
a plaster splint, is that sometimes called half a cast?
Sometimes it's called half a cast or a soft cast, something like that, yeah.
And it's made of plaster of Paris, right?
Correct.
And plaster of Paris hardens like a cast does, correct?
Yes.
So other than the fact that it's a little smaller than a cast that goes around your whole hand, it's just as hard as a cast that would be put on a broken arm or a broken hand, correct?
Well, it's softer on the side so the fingers can expand for swelling. So it's not fully, the plaster appears circumferential around everything. So there are areas that are softer to allow for swelling.
But the parts that are covered with plaster of Paris are just as hard as any other cast, correct?
Correct.
Why does this matter?
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
All right.
Permission to publish.
Yes, yes, sir.
Dr. Culber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Ms. Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Overruled.
I mean, he had his other hand available, so.
No further questions. Thank you.
All right, redirect.
Dr. Colbert, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
And why did you call it a soft cast?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential. So there's soft spots to it.
And where are those soft spots located again?
Usually we'd put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have injured, damaged the cast.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
I don't recall. But nothing that comes to mind.
Ooh, that
Could
wasn't
Mr.
solid.
Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Kohler.
All right. Thank you, sir. That concludes your testimony. Thank you. All right.
That was
Your
not
next
that
witness.
good. Hey, Misdemeanor.
Plaintiff calls Richard Marks, Your Honor.
All right. Mr. Marks. So just a reminder that you're... Hold on. Hold on. Just give us a second. No, sir, you've already... Just a reminder that you're still under oath. Okay, sir? All right. Good morning, sir. All right. Yes, ma'am.
Thank you, Your Honor. Welcome back, Mr. Marks. You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals every day for productions.
Oh,
and for
God, it's this guy
individuals
again.
in the trenches, negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yes.
Have you been asked to analyze that testimony and provide opinions in response?
Yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement, it's a multi-picture agreement, and it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors. the next morning at 9, and you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the Stars Born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary when she got the part was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times, to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go, and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated normally. They are in some instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them, and then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals. And by that I mean that you assume success. The reason you go from the first Justice League movie where Ms. Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Ms. Arnold was referring to, a renegotiation, if you will, for the 3rd movie. Instead of doubling her salary, Ms. Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I've said, that would now be, after a healthy first payday, it's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it. Ms. Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left, and you want that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take. And unfortunately, Ms. Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except she's asking you just to believe her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that, but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks. Are you familiar with her testimony that Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with, and I think there is reasons to negotiate. They weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million, or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum. To assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character. And Ms. Arnold says that Ms. Heard's breakout moment, her Star is Born moment, is Christmas 2018. If that's true, and I don't think it's true, those moments don't normally happen to supporting cast, but if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in, to take advantage of this hot star and to sign them up. And we have, from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Ms. Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the $1 million Miss Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a comparable.
Unresponsive to.
All right, I'll sustain the objection. Next question.
Mr. Marks, we'll get to some of those issues in a moment, but I want to take you back for a second. I believe you testified a few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a fourth option for Aquaman 3 or another movie where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Again, this is a business of personalities. We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't, what Ms. Arnold shows you is these non-comparable actors, they had endorsement deals. But she doesn't show you, when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these deals, why wouldn't she? But for the statements that happened 16 months later, and I guess my primary question is what happened in the 16 months, even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an opinion.
What's your opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role, and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes, and it was $200,000 an episode. And Miss Arnold is from somewhere in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode. And again, in those 16 months, there were no offers for series at $1 million an episode. In fact, her only series is the $200,000. And if you look at her resume, the series that Miss Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Miss Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode, if you're to believe that, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes. He was in, again, there's not a comparableness there.
We spoke a few minutes ago about the test option agreement. What's the significance of the option part of that agreement?
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be, but it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed. You're hired to play the role. In an option agreement, once they exercise the option, for that movie, it becomes a guaranteed contract.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently rehired?
I heard that testimony.
Is that consistent with your experience of the film industry in connection with these multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring, and in my experience, in almost 5 decades in the business, doing this type of work, not talking about it, not consulting. I mean, I have, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, it's not a contract till they option it, and they pick up their option, and at that point, it's a guaranteed contract, and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath basically saying that there was this discussion of chemistry. That
objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that you were. It's hearsay like yesterday. I mean, it's hearsay.
I'll overrule the objection. Go ahead.
Thank you.
I didn't hear.
Go ahead, sir.
Overruled. You can continue, Mr.
Oh, I was surprised to hear Mr. Hamada say that they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor. You're either going to exercise or not. And that was quite a bit of candor from someone at his level. And so, therefore, I take it at face value. I think he felt that he was under oath and he was telling the truth, but it wouldn't be.
Objection, Your Honor.
I'll sustain the objection.
Mr. Marks, are there circumstances where a studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor but not play them, pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we'd still have a right to recast and not make the movie. We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
I heard that.
And what's your opinion of those actors as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't
Objection, Your Honor,
comparable.
hearsay.
And I believe same response, Your Honor, that it was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
Or you can cross-examine overruled.
Overruled. You may continue, Mr. Rose.
Again, they are not comparable. Jason Momoa was Aquaman. Chris Pine was Captain Kirk. Gal Gadot was Wonder Woman. Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Ana de Armas, when she was in a movie that they call, her breakout, it was as a nude poster. She's been in an ensemble piece, Knives Out. These are not comparables. Now, Ms. Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career. But she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She just she set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables.
This is so boring.
She built like this house of cards on nothing. She showed us with her words the beautiful clothing that the emperor was wearing, but we could see, if you know the business,
Objection, Your Honor.
that he wasn't.
Beyond the scope of the question.
All right, I'll sustain the objection. Next question.
Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to Mr. Momoa as an actor with equivalent franchise experience who was able to renegotiate his salary for significant increases in bonus?
Yes.
What's your response to that opinion?
Again, he didn't have comparable franchise experience to Ms. Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And you can say the words, but I saw nothing from Ms. Arnold to back it up, something to build on, which if she was a negotiator in the trench, the studio negotiator would say, okay, so show us. Where's the comps? Let's talk numbers, because ultimately that's what we have to get to, not just because you say it's so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Well, I mean, first, it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings, precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings. And I didn't see any, Ms. Arnold talk about past earnings at all, except the earnings in this rarefied superhero 4-picture deal where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15 small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the pre.
Nah, this is today, and I'm about to shut down because this guy is boring me to tears. And I keep thinking of all the other stuff I need to get done, and this guy is just, this is almost like a waste of time, in my opinion. And here I am sitting here wasting all this time listening to this guy talk about absolutely nothing of relevance to me.
Adam Waldman's statements 16 months later. So I think the timing.
Sure.
This is like one of those lawyers who just wants to hear himself talk. Look at him trying to schmooze the jury. I need a nap after today, let me tell you. But I'm going to give this guy like 2 more minutes and then I'm shutting down. Because this guy sucks. Ugh. Ugh.
Mr. Marks, what's your overall assessment of Ms. Arnold's opinions in this case?
My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something about our business, but not about negotiating deals. She may have gotten someone at the Endeavor office to breach confidentiality, but she never laid out the building blocks.
Excuse me, objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes deals.
No further questions.
All right, cross-examination.
Good morning, Mr. Marks.
Good morning.
So you agree that studios use comps to negotiate deals, correct, with actors?
Sometimes they do.
And you have an issue with the comps that Ms. Arnold used, correct, as you testified to?
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, I mean, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to...
That's not my question. Are you offering a different set of comparators than what Ms. Arnold used?
I'm not here offering comparators. I'm saying what she offered are not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms. Heard's comparisons are where you
That
look.
was my question. Motion to strike after the...
All right, we'll strike after that. Just answer the questions, Mr. Marks. Thank you.
Now, you're a deal maker, correct?
Yes.
What actors have you negotiated for in superhero movies?
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd and Will Ferrell on an Apple series. Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for in a superhero movie?
As I sit here now, I can't remember a superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct. Your answer
Okay,
is no.
all right. So as I sit here, I can't think of a Marvel type superhero movie that I've negotiated. Although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out. What he was earning and what he renegotiated to, and he is Aquaman Man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any testimony under oath that that's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent option contract, correct?
Yes.
Okay. And you agree that for if there's an Aquaman 3, Ms. Heard would have an option to receive $4 million, correct, for the movie?
Well, actually, you would language it. Warner Brothers would have the option to engage her.
And if they engaged her, she would receive $4 million, correct?
She doesn't have the option to refuse. They have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone. That could be other type of studio movies.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters in movies that don't appear in the next movie.
But a female star in a breakthrough movie in a superhero movie, can you identify any actress who's not gotten another studio movie after that?
Well, after Miss Heard's breakthrough in 2018, she did get Aquaman 2.
Aquaman 2 was already, she already had the option for Aquaman 2,
all right.
correct?
So she did, Miss Heard did not get any movies after 2018, long before the Adam Waldman statements.
Other than Ms. Heard, can you identify any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie?
As I sit here now, I haven't been asked to research that, and I can't. That would be a normal thing.
And you're not providing an alternative number for Ms. Heard's damages, correct, for the jury?
Correct. I'm not providing an alternate number. I think, she's been more than adequately paid.
I'd move to strike after no, I've not been provided another number. That's all. I mean, my question was you're not providing another number.
I think it's in fairness and the full answer of the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay. All right. No further questions.
All right. Redirect.
Mr. Marks, in response to some questions from Mr. Lederhaft, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long career that I mainly forget what I've done, but I negotiated all the contracts for Pinocchio, if you will, that was produced. Is Coming to America the original? Is that a fantasy movie? The Golden Child, is that a fantasy movie? Yeah, and by the way, I may have negotiated contracts, and ultimately the film wasn't made. But as I sit here now, those are the only ones that come to pass. If I was looking at my resume or going through my files, I might think of others. But there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhaft's questions that you have negotiated some deals for Chris Pratt and Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have, but don't quote me because, that's not my genre.
No further questions, Your Honor.
All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right. Your next witness.
Plaintiff calls Michael Spindler.
Michael Spindler? You've testified previously, correct, Mr. Spindler? All right. Just a reminder that you're still under oath, okay, sir? Yes. All right, thank you. Yes, sir.
Thank you. Good morning, Mr. Spindler.
Good morning.
Can you remind the jury who you are and what you do?
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages resulting from 3 statements made by Mr. Waldman?
Yes, I do.
Do you have an opinion of that claim?
I do.
All right.
No, I think he was saying that he's closed deals in every genre. That's how I took it. Not that he's closed every deal, just that he's closed deals in every genre. But I am going to shut down because I have so much to do and this is like nothing new. And I feel like I'm bored to tears and falling asleep and I need a nap. But I'll be back later. There's just really no point in me wasting all this time when nothing's happening. Except the same people going on and on. But I will be back this afternoon, most likely. I will see you guys in a little while. Have a wonderful day. And I'm sure they're going to lunch any minute anyway. But I got to get so much done. So I will see you guys in a little